Hi, good day everyone. I am Elginbert Abogan Akak, presenting the oral question and answer of CLJ401. Number 1. Who must prosecute criminal actions? All criminal actions commenced by a complaint or information shall be prosecuted under the direction and control of the prosecutor. Number 2. When is a complaint or information deemed sufficient? A complaint or information is sufficient if it states the name of the accused, the designation of the offense given by the statute, the acts or omission complained of as constituting the offense, the name of the offended party, the proximate date of the commission of the offense, and the place where the offense was committed. Number 3. What are the elements of a prejudicial question? The previously instituted civil action involves an issue similar or intimately related to the issue raised in the subsequent criminal action, and the resolution of such issue determines whether or not the criminal action may proceed. Number 4. Define preliminary investigation. When is required? Is an inquiry or proceeding to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and should be held for trial. Number 5. What is inquest investigation? Section 7, Rule 112. When a person is lawfully arrested without a warrant involving an offense which requires a preliminary investigation, a complaint or information may be filed by a prosecutor without need of such investigation provided an inquest has been conducted in accordance with existing rules. Number 6. Define arrest. How is it made? An arrest is made by an actual restraint of a person to be arrested or by his submission to the custody, the person making the arrest. Number 7. What are the instances when is an arrest without a warrant is lawful? A peace officer or a private person may, without a warrant, arrest a person. Number 8. What is bail? What are the kinds of bail? Security given for the release of a person in custody of the law furnished by him or ombudsman to guarantee his appearance before any court as required under the condition hereafter specified. Number 9 is given 5 rights of the accused. To be presumed innocent until the contrary are proved beyond reasonable doubt, to be informed of the nature and cause of the accusation against him, to be exempt from being compelled to be a witness against himself, to have speedy, impartial, and public trial, to appeal in all cases allowed and in the manner prescribed by law. Number 10. How is arraignment made? The accused must arraign before the court where the complaint or information was filed or assigned for trial. Number 11. What is plea bargaining? Plea bargaining are the agreement between two defendants and prosecutors in which defendants agree to plead guilty to some or all of the charges against them in charge for a concession from the prosecutors. Number 12. What are the instances when the arraignment may be suspended? The accused appears to be suffering from an unsound mental condition which effectively renders him unable to fully understand the charge against him and to plead intelligently thereto. There exists prejudicial question and a petition for review resolution of the prosecutor is pending at either the Department of Justice or the Office of the President, provided that the period of suspension shall not exceed 60 days counted from the filing of the petition with the reviewing office. Number 13. When does double jeopardy attaches? When an accused has been convicted or acquitted or the case against him dismissed or otherwise determinated without his express consent by a court of competent jurisdiction upon a valid complaint or information or other formal charge sufficient in form and substance to sustain a conviction, and after the accused had pleaded to the charge, the conviction or acquittal of the use, or the dismissal of the case shall be a bar to another prosecution for the offense charged, or for any attempt to commit the same prosecution thereof, or for any offense which necessarily includes or is necessary included in the offense charged in the former complaint or information. Number 14. What is the order of the trial in criminal case? After the trial conference, the court shall issue an order citing the action taken, facts stipulated, and the evidence marked. Number 15. When an accused be discharged to become a state witness. When two or more persons are jointly charged with the commission of the offense upon motion of the prosecution before his case, the court of the may direct on a more of accused to be discharged with their consent so that they may be witnessed for the state when after required of the prosecution to present the evidence and sworn statement of its purpose state witness of a hearing in support in this charge of the court satisfied. Number 16. Define judgment. What are its contents? A judgment is the adjudication by the court that the accused is guilty or not guilty of the offense charged and the imposition on him of the proper penalty and civil liability. Number 17. Define search warrant. A search warrant is an order in writing issued in the name of the people of the Philippines, signed by a judge and directed to a peace officer, commanding him to search for personal property described therein and bring it before the court. Number 18. What are the requisites in order that search warrant be issued? A search warrant shall not issue except upon probable cause in connection with the specific offense to be determined personally by the judge after examination under oath or affirmation of the complainant under witness. He made procedure and particularly describing the place of the search and the things and the says with may be anywhere in the Philippines. Number 19. What are the personal properties that may be subject of search and seizure? Subject of the offense stolen or embezzled and other proceeds or fruits of the offense or used or intended to be used as the means of committing an offense. Number 20. What are the qualifications of witness? All persons who can perceive and perceiving can make known on their perception to others may be witness, religious or political belief, interest in the outcome of the case, or conviction of the crime, unless the otherwise provided by law, shall not be a ground for disqualification. That's all, everyone. Thank you.